Welcome back. This is the Anthony Kirkland death penalty sentence. I am once again honored to have one of our great guests at the Law&Crime Network with us, Judge Ashley Willcott. Judge, how are you?
Good, Bob. Thanks for having me today.
Yeah,
always good to see you.
It's great to have you, especially to talk about the complexity of trial work like death penalty litigation. We have a little short period of time before we go to break, but let me ask you, Judge, as a prosecutor, I think we even said this the last time we were on, I say it all the time, you never want to be retrying a case. It is not only more difficult for a prosecutor to do that in general cases, but moreover, it has a tremendous impact on the victim's family. And usually, Judge, the #1 way cases are reversed, especially death penalty cases, are improper comments made in openings and summations.
Right. I would agree with that, Bob, completely. But in this case, I don't think they're retrying the case. The prosecution has done a great job of really showing the aggravating circumstances and the fact that this was a girl, right? A girl, perfect teeth, SpongeBob pajamas, honestly, always had a backpack, didn't have it with her that day. And so they really are trying to paint to the jury, here's a very vulnerable victim that's been murdered with aggravating circumstances.
Yeah, Judge, I just want to go back for a real quick minute to the fact that we're retrying the death penalty phase of this case. And it was over a comment the prosecutor had made with respect to saying that if essentially he's already serving life without parole for 2 previous murders, and if you don't convict him of the death penalty, he's getting these 2 girls' murders, the ones we're trying right now, for free. And again, I really think it's important to let our audience know that prosecutors have to be very careful to only comment on evidence and not inflame the passage of the jury. And moreover, I don't think it would have changed the actual verdict. I think it's such a shame that we're here right now even doing this over again.
Right. And you're right. That's #1 grounds for appeal. And it's going to get overturned when they do that. But that is part of the trial skills technique. You've got to, like you already said, include anything that was not evidence during the trial period.
Okay, Judge, hold on 1 second. You're breaking up a little bit. We're going to clear that up. Ladies and gentlemen, we are at the Anthony Kirkland resentencing case. We're going to go to a short break and come back, listen to some testimony, and break this down with the judge. Welcome back to the Law&Crime Network. Okay, so what we had there was the transcript of Barbara McAvoy, who was the sister of Mary Jo Newton, who was 45 years old and killed by this defendant, as was another person, which he pled guilty to those, confessed and pled guilty, and got life in prison for those. We are now in the Kirkland case for the resentencing in the penalty phase for these 2 young girls, Miss Crawford and Miss Kenny, who were 14 and 13 years old, respectively. And so what you're seeing in court is a transcript that was read in the previous trial. It's now being retried, of a previous murder case in which he pled guilty and was sentenced. I have Judge Ashley Willcott with us. I know it's a little bit of a rubric to go through here, but Judge, me and you are both commenting, offline. Each state is different with respect to how they do death penalty cases. I've done them myself personally, and I could say in at least Jersey, this kind of information about victim impact testimony from a previous murder that a person was being sentenced would not be admissible by the prosecution because it's almost being held responsible twice for the same crime. What are your thoughts?
I think that's true in this state as well. I'm in Georgia, but in Ohio, so they do look at the aggravating circumstances, and I think we have to figure out how that ties in, if it does, to those aggravating circumstances. Bob, one of the things I'm confused about, and you probably know, but in watching this testimony, is I know this is the resentencing, right, and the repenalty phase because the Supreme Court had sent it back down and they had to redo it. So is it in fact for this particular victim or not that this sentencing will apply? That's just my confusion.
Yeah, I think it's going to be resentencing with respect to both of these victims, as I understand it. It's a very good point, Judge. And it goes to underscoring the point that we brought out a couple of days ago, that death penalty cases are handled differently state by state, and the admission of evidence is very different. And that can lead to very disparate results, because as a prosecutor, I would love to be able to pound a defendant on a death penalty case with multiple other murders they committed.
Right, Bob. And in fact, that's one of the things that proponents who are against, I should say, those who are against the death penalty and argue against it, that's one of their arguments, right, is that it's not the same nationwide. And so it does depend on the particular state in which you're convicted.
Yeah, absolutely. And listen, that's why I love having you on, Judge Ashley Willcott. You do a great job down there in Georgia in helping us all figure out this case. It's fascinating. You were in the death penalty phase of the Anthony Kirkland case. We're going to go to a short break, and on the other side of that, we're going to come back and we're going to break this case down a little bit further. This is this really sad case, Anthony Kirkland, and on my way over here as I was preparing for this and some other stuff that we're going to be presenting to you today, I got to be honest with you, as a former homicide prosecutor who's been in this business for 30 years and seen a lot of bad stuff, this is really about as bad as you can get. We have Judge Ashley Willcott with us, one of my favorite guests on here. She's really squared away. She knows her stuff. And we were talking before we went to the break about a little odd that they're presenting testimony through a transcript from a previous hearing from another woman that he's serving a life sentence for having killed in this death penalty case. And I had explained that you would not be able to get away with that, at least in New Jersey in death penalty litigation, how the states have different laws. But I asked the judge to do me a favor, and she is great with research. She jumped right on it. Let's look at the aggravating and mitigating factors in Ohio, more over the aggravating factors. And I asked the judge, I said, is there an aggravating factor that would make this testimony relevant? What'd you find, Judge?
I found, the Ohio statute anyways, this is not one of the specific things laid out to say this would be an aggravated circumstance. So some examples of aggravated circumstances in the state of Ohio are things like killing law enforcement, if you kill someone who's pregnant, a pregnant woman, and then there's one if you also dismember in a certain way. So I'll leave it at that without the graphic details. All of that to say I don't see anything that this falls within. But, Bob, the one thing I did find is we know that different states have different laws about or different rules about victim impact statements. And I'm just assuming Ohio is one in which these can be utilized, even in death penalty cases, which I've not seen before.
Well, it clearly could be utilized because the judge is admitting it. So, I mean, obviously it has some relevance under Ohio law. It just seems odd with respect to our understanding of aggravating factors in our states. Judge, I appreciate that explanation. Let's go to the prosecutor's opening statement that was done earlier today. And on the other end of that, get back to the judge and we'll discuss the tactics of this case. Hey, I'd like to just tell you that we were going to go to the opening statements in the prosecution of Kirkland. At least that's what I told you. But I was seeing whether or not you were paying attention that we actually did the statements in the Colley case, which is another case that we covered gavel to gavel. But you know what? A good trial lawyer and a good judge like Judge Ashley Willcott, who is with us today, knows how to roll with these punches and knows how to make lemonade out of lemons. So, Judge, we just listened to this in the Colley case. Now, the Colley case is one in which there's some mitigation evidence. There was anger, frustration, this picture that came. He did a horrible thing. There was a court proceeding, which you can appreciate, that occurred earlier that day. And then he went off. He was jealous. He was upset. He found sex toys. A much different kind of case than what you have in the Kirkland case, because there you have two beautiful little girls, 13, 14 years old, minding their own business, no relationship, out in the world, being dragged into the woods, raped, murdered, and burned. And this can really show you the difference between a case that has a defense for death penalty and one that doesn't. What are your thoughts?
Absolutely. And so no victim should be a victim of murder. But having said that, you're right. In the one case, we have two who are unknown random victims that could happen to anybody, right? In the other one, you have a long history. It's a wife. There's jealousy. There's anger. There's all these other emotions. The other thing I'll put out is the time frame. So in the Colley case, the time frame that it took him from being angry after a hearing to committing the murders is over a longer period of time. These others were just randomly snatched off the street, so to speak, and randomly killed. Two different scenarios, two different arguments if you're arguing the death penalty. And
you hate to judge how a person is killed, but this is what we do in our world. Being shot is a horrible thing, but being raped and burned to death is clearly bad. We got to take a quick break. Please stay with us on the Law&Crime Network, gavel to gavel coverage with Judge Ashley Willcott.
Here are today's top crime stories trending on lawandcrime.com and across the country. The attorney for convicted rapist and former Stanford University swimmer Brock Turner is trying to get his attempted rape conviction overturned. Turner's attorney argued that his client did not intend to rape the woman since he had his clothes on when he was caught. Turner was convicted of sexually assaulting an intoxicated woman after he was caught on top of the half-naked and unconscious woman by 2 Swedish graduate students. He was sentenced to 6 months in jail, which caused outrage on social media. Turner is now required to register as a sex offender for the rest of his life. Authorities in Georgia are launching an investigation after video surfaced of a shirtless man hanging onto a moving car for several miles. The driver of the car, 17-year-old Viviana Deyete, claims the man came out of nowhere and jumped onto her car while screaming about being in danger. Deyete drove several miles before the shoeless man dismounted her car. The man was taken into custody, and authorities believe he was hallucinating at the time of the incident. A man in Maryland who was previously convicted for the killing of his 7-month-old son was arrested in the killing of another child. 35-year-old Francois Brown of Baltimore was charged with first-degree murder in connection to the killing of his girlfriend's 18-month-old son, Zaray Gary. The autopsy of the child showed he had a broken clavicle and internal injuries, and investigators believe Brown beat the child. Brown served nearly 3 years in prison for child abuse resulting in death for the killing of his son, Kendall Brown, in 2012. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
You know, I gotta love the top crime stories, and we're dealing with so much trauma with respect to the cases that we got going right now. Judge, I gotta ask you a question. Usually when a shirtless man is jumping onto my car, I don't usually drive like a couple of miles away. I usually stop after 4 blocks. I have a 4-block rule, and a shirtless guy jumps on your car, you go no further than 4 blocks before you get him off. What do you do?
Well, you know, I think in this case, maybe she was thinking, hey, you know what? You want to jump on my car and make me uncomfortable? I'm going to speed down the road. But again, a story out of Georgia. I feel like we keep getting these really entertaining stories out of the state of Georgia. I think she should have stopped, but, you know.
Well, you know, Judge, it could be it's so hot down there, and it was so hot here a couple of days ago. Actually, I have a pic on my social media of me sweating profusely. Maybe he was just trying to air himself out, cool himself off with that sultry weather that you got in Georgia. But listen, folks, in the Law&Crime Network, we're going to cover this Anthony Kirkland penalty phase. The jury's coming back into the courtroom. And so let's just take a real quick look at what's going on in there. We'll be back with you, Judge. Welcome back. So we are listening to Howard Grant, Cincinnati PD, crime scene detective, homicide detective. He's now a sergeant with the police department, and he's giving us information with respect to the 2006 cold case murder of Cassandra Crawford and Esme Kenny, and he's talking about how they connected those murders together. Eventually, he's going through crime scene stuff. Judge Ashley Willcott is with us. I think this prosecutor and this police officer, as we would say in the business, are dancing very well together in getting what could be typically sometimes boring testimony, really animating it with these pictures and bringing those jurors right into a horrible place. What do you think?
I agree. And Bob, like you already pointed out, you don't want to retry the crime. That's not what the point of this phase of the trial is for the death penalty request by the prosecution. And so by doing that and using the details, things like, oh, the burn scene, there was a 4x4 piece of lumber used to poke to keep the fire going. These are the things and the facts that you point out that the jury's going to, you know, hanging on the edge of their seat to hear these details.
Yeah, and I think that they've done a really good job at explaining how police go about things and how it's not like NCIC, this is the real world, which is very important because jurors can be confused by stuff like that.
Oh, absolutely. They need to address that. And they're given a very real picture of this is exactly what we found and all of the little pieces that go together to be aggravating circumstances.
Great, Judge. Listen, we got to run to a break, and on the other end of that break, we're going to come back to the testimony and break it down with the great Judge Ashley Willcott. Well, that looks like that's that. They're taking a break. I'm not sure if it's for the day or for the afternoon. It's hard for me to make that out with the judge, but I do have a great judge with me that can break this case down, Judge Ashley Willcott. And we have been talking about this case. Prosecutor did a really great job with that last detective. He was a crime scenes detective, and he is the person that actually worked part of the case that led to the solving of a cold case of these 2 beautiful girls that were murdered viciously by this defendant, Mr. Kirkland, in 2006, 2009, 14 and 13 years old, respectively. This is the penalty phase of the case. I say this guy's going to go down like an HOTFLAHSH. That's hot flash. But before we do that, let's go to the top crime stories, and on the other end, we'll come back and we'll talk to the judge. Yeah, I don't know why this guy hanging onto the car in Georgia, Judge Ashley Willcott, she can only speak. She's an expert in all things Georgia. Judge, this is like something that keeps going on in the tape of my head. I'm going to be thinking about it all the time. He was calm, cool, collected, shirtless. He's just hanging onto a car. She's just continuing to drive down the road. What's up, Judge?
I know, right? So the best thing to do, obviously, is pull over so you don't hurt him. But I think this driver must have said, you're jumping on my car. I'm taking off. She probably went faster and further. I don't know how to answer it, but that's what happened.
You know, I don't know why I'm breaking this down in my brain here, but I get that. If you were scared and you're like, there's a maniac on my car and you're swerving, trying to get the person off, or you stop the car and you run out. It was just like he was calmly hanging on and she was just calmly going on her way. It's kind of like a fly on a windshield.
Yep. And can you imagine if you're driving alongside of that and watching it, you're thinking, that's not what I'm seeing. There's really a person on that car.
Well, Judge, we don't know this, but I'm going to make this up in my head that while that went on for several miles, no one even around it thought enough to pick up the call and say, call 911. It's just like a common thing. There's a guy hanging on a car, no biggie, and they just kept on going.
I don't know. Don't know how to answer, but welcome to Georgia, Bob.
Well, listen, I have family that live down there, and I love us. There's a boiled peanuts that you got down there and all these different
Absolutely.
things. Oh, my God, they're awesome.
Yeah.
But listen, Judge, in a serious note on that case, it's funny. I'm thinking in my head, God forbid, like you just alluded to, the guy fell off the car and was either struck by her or another vehicle. These are the kinds of cases where people can find themselves all of a sudden that driver of the vehicle with either some sort of reckless conduct like manslaughter potentially if the person dies.
Absolutely, the consequences, right? And they're unintended consequences. She probably didn't think through in the moment, in the heat of somebody being on her car, jumping on her car, that could happen. But yeah, we do see those kinds of crimes. Absolutely.
All right, listen, I promise everybody in the chat rooms and everybody watching this on the Law&Crime Network, and including you, Judge, I will not bring this up again unless we do crime stories again and it comes up again, because I love that story. And it's good to have a little bit of a laugh when you're dealing with something like the Anthony Kirkland case, because this is no laughing matter. We just got done listening to Howard Grant. This guy is a squared-away detective. He's got a lot of background, a lot of experience, makes a really good appearance in court. You could tell that him and the prosecutor had this down solid. That doesn't just happen miraculously in the courtroom. There's a lot of pretrial preparation for that. The prosecutor animated that evidence. Judge, we were talking before we went through those breaks about how even though this isn't the guilt phase, it's the penalty phase, that bringing the jurors right into that crime scene with these pictures is going to have a very powerful, emotional impact.
Absolutely. And we all have to admit, I agree with one of the chat room comments. Boy, that detective, he was really in the crime scene. He was very personable, very charismatic. I'm sure the jury was brought into his demeanor that he had on the witness stand. And he went through all the things that are really important for the jury to hear: the use of an accelerant, the use of a stick to poke the fire. All of the markers, to me, had a lot of impact. When you see in one picture all of the markers for where all the different evidence was, this was a crime scene that was pretty brutal, like you already pointed out, and all the different things that happened to the girls is well documented, and they show it visually, which is very smart on the behalf of the prosecution.
And we have time for one more question, and then we're going to get to the prosecutor's opening statement. And something that just, again, resonates with me very deeply. I have had 2 murder cases, Judge, that I tried where there was copious amounts of evidence that was collected that was seemingly innocuous, and literally, and I mean literally, Judge, on those 2 occasions, the defendant took the witness stand, and of course, we don't know typically, because they didn't give a statement, what the defendant was going to say, and it wasn't until cross-examining that witness that all of a sudden something in the back of my head said, oh my gosh, there's 2 pieces of evidence that I thought was just nonsense, had nothing to do with the case, that actually when the defendant was crossed on it, because thank God you thought of it, literally one was left open mouth, and I said, you don't want to answer that question. They said no, and I moved on. I said, fine, I get it, but it made the point to the jury. And the other one, the guy couldn't explain anything other than to say, I obviously lied to the jury. So knowing your evidence and at what may be nothing in the beginning could be all the way through a trial to when a witness testifies where the light goes on, bing, that's important. Have you experienced that?
Yes, and it's that moment, right? If you're a good trial attorney, that's what you want to achieve. And if you're a good trial attorney and you put all the evidence in as you should, those are the moments that we live for, so to speak, for our respective side to say, wow, that's it, Nirvana, we just did exactly what we needed to prove.
Yeah, because in a case like this, Judge, especially when they're doing the kind of job that appears that this squared away officer was doing, you can collect literally thousands of pieces of evidence, and you got to have that in your head so that you don't miss anything. That's why you go crazy day and night, even when you're trying a case, thinking, working, continuing to read, continuing to prepare if you're going to be effective. But listen, let's go to those prosecutors' opening statements, and we'll talk to the judge on the other end of that. So, Judge, we're listening to the prosecutor's opening statement there, and we were talking before about the admission of this other victim impact testimony. One of the lines he uses, a trail of human destruction, the prosecutor. A very powerful line. So what are any continued thoughts about whether or not this evidence, how it's going to fit in or why it's being allowed? Clearly, it must be lawful because the judge ruled that the prosecutors can use it. But, boy, that is really powerful evidence. It's hard to overcome a juror's mind when they hear something like that.
It sure is. Actually, his opening gave me a little bit of clarity because he described that aggravated circumstances, in this case, is the course of conduct to kill two or more people as a serial killer. So I think he's tied that into how it's aggravated circumstances and how he can now bring that victim impact statement in.
Yeah, and so, you know, essentially there's all these based on the legal parameters that are allowing this to happen. We're going to talk a little bit down the road about, yikes, what do you do as a defense lawyer when you are involved in this kind of case trying to spare this guy's life? This is a tough one.
Yeah, this is a tough one. It's going to be interesting to see what stance or position they take. But again, all they have to do, what they have to do is have one juror. That's it. Just one juror say, guess what? The aggravating did not outweigh the mitigating for me. Now, I think it's a tough row to hoe in this one, but we'll see.
I agree with the judge. We're going to go to a quick break, and on the other end, we'll come back with some more commentary. We're breaking down this Kirkland case. Prosecutor, Judge Ashley Willcott, is with us and joining us. Prosecutors laying out in the opening statement this path of human destruction, trail of human destruction, as he puts it. And let's not forget, Judge, while he's serving life without parole for two other murders, he had committed a murder even before that. I have the date here somewhere. I think it was 1987, for having killed and burned his girlfriend back then. And he had gotten a minimal sentence, obviously, where he got out afterwards. I believe it was something like 13 years. I mean, you know, this is where people say the judicial system is failing people because one murder, he's out, two other murders, he's spending life, you know, but again, they didn't know it at the time, spending life, you know, without prison. And then he's got these two 13 and 14-year-old innocent kids who were just taken from this world in such a horrific, brutal, horrible way, abducted, raped, you know, killed, then bodies burned. It's just such a bad thing. And this is what leaves a taste in people's mouth that the judicial system failed them. You as a judge, what do you say to people that have this feeling?
You know, I have to say I don't disagree. After the first murder, you think, you know what, he shouldn't be back out on the street. We need to punish him, but more importantly, we need to protect society. Having said that, all of this is dictated, as you well know, Bob, and listeners need to know and viewers know, that it's because of the statutes in a lot of states. And so there's mandatory federal guidelines for sentencing that judges are required to follow in sentencing for convictions, but some of those guidelines may not be ones that people think are generally long enough or acceptable, and it doesn't mean that those who commit crimes won't get out of prison and perhaps commit another crime. So, and then we have the overcrowding of jails, so sometimes when they're subject to parole and can get out, that happens, right? And they actually get out. So it's a hard balance for a judge, but we're bound by the laws.
Yeah, and Ashley, you know, listen, this staff here at the Law&Crime Network, you cannot believe them. If you are even off by 3 years, you're going to get a message. It wasn't 13 years, it got 16 years, 13, 16, 17, 14. This guy killed his girlfriend, set her on fire, and here we are years later. And by the way, thank you, Kathy Russin and the producers for that. It's always great to be accurate. But here we are with Ksenia and with Esme, Kenny, and Crawford, 14, 13, and their bodies are being burned. But, Judge, I'll give a counter argument to that. Most people get out that commit murders and don't commit another murder again. And sometimes we hit flies with sledgehammers by having The answer to discretion is mandatory sentencing. Take it out of the hands of the judge. Make sure that they stay in there and hit those flies with sledgehammers. It's really hard to balance the equities between these things many times.
I mean, I do agree with that, but I'm going to say, regrettably, I see too many repeat offenders, maybe not of the same crime such as murder, but maybe some other type of crime. And so it is a hard balance, but I do think there are, regrettably, a lot of repeat offenders.
Yes, definitely. Listen, we're going to go back to the opening statements, and we're going to come back on the other end, and we'll discuss it. Wow, Judge, that is some pretty graphic testimony, and I've actually tried a couple arson homicide cases, and I can tell you there's nothing more compelling than I think the juror's visceral reaction to it may not have been burned in the course of the murder, maybe it was afterwards, but it's just really, really graphic to think that these two young girls were trashed this way by this guy.
Absolutely. Trashed is a really good description because he goes into the details, all the teeth knocked out, nothing was on them, all the burns. So it definitely pulls in the emotion of the jury to understand how brutal these murders were.
And let's just talk real quick about intonation of the prosecutor. You know, everybody's got different styles. When I used to train, I used to try not to change personality. Some people are more passionate and fiery. This prosecutor's got this very staid, very matter of fact, while he's describing this gruesome evidence. I think it's pretty effective.
I think it's effective, but it's so even and level that I worry or wonder about, is it more of a feeling like he's droning to the jury versus more emotion, so they're more compelled to listen to each word? That I don't know. It is a personal style issue.
Yeah, well, I clearly would be, no pun intended, on fire with a case like this if I were prosecuting and have. And so let's go to a break on the other end, come back with the judge and talk more about the case. Anthony Kirkland is done for the day. I'm here with Judge Ashley Willcott, who's been bringing it home, bringing the fire. I'll throw it at you, Judge, with respect to these commentary. And we're in like trial nuances now, personality, skills, style. Not many of us have an opportunity to be able to do that unless you've actually been there in the fire, literally, and doing it yourself. You were talking about how you felt it was a little, maybe potentially a little flat or a little matter of fact by the prosecutor. And I get that point, and certainly a person like me just can't be that way. So you would be yelling and screaming and on fire without trying to get anybody upset. But nevertheless, the facts are going to ultimately control your case. So I think that he was effective, let me put it that way, in getting the evidence across and not taking too much away from it. But I have an interesting comment from one of our chat room people that I thought I'd bring out here, because we all know that it's what the jury is thinking that's most relevant, not how smart you are, or not even maybe how good your facts are. In the end, do they like you? Do they believe in you? Do they think that you're a truth teller? And it comes to so many different human emotions there. And one of the chat room people made an interesting comment that they don't like that there's a young woman sitting at the defense table. Is this being done as a prop because there are two young girls that were killed here? It's a very perceptive comment that could have an impact on even a juror like one of our chatters.
Super perceptive. And Bob, absolutely, I think that came into the defense counsel's mind to have a young woman sitting at the table. That's part of the stage that trial is, right? And so it is almost like a play, in that you have to think about all of those things and how it may affect a juror. So I think that is such a great observation, and absolutely I would believe that that could be something defense purposely did.
Yeah, you know, I never played that kind of game at all. To me, the people I wanted sitting at that counsel table were the very best people I could get as lawyers that were passionate about the case. I know that gamesmanship goes on. I think it's a mistake because, like our chat room person on the Law&Crime Network pointed out there, and I suggest everybody go there because there's great commentary by those folks in that space. This can have a negative impact on the credibility if it was done for that reason, but who knows? Judge, I actually had a friend who sat on a death penalty case and said they were impressed by the prosecutor because he always had a file box with all of his files organized on it, and that was actually being discussed in the deliberations.
Yes, and he is very effective in presenting the facts and being very well organized, which, as you well know, Bob, you have to be organized to present. These trials take every ounce of your energy. And the other part of what I'll say about his demeanor is it certainly takes away from anyone thinking that the only reason he wins is because of how passionate he was in his opening. Instead, he's laying out the facts and he's very calm about it, but his facts can support, I think, death penalty in this case, so it's a good use of his demeanor.
Well, Judge, you know, now me and you could just keep rolling on and on and on, because you just keyed me into something that I literally heard one time in a case on appeal, and you got to win not just the case, but I would say to my prosecutors, you got to be successful on appeal. I thankfully was never reversed on a conviction, but I actually, part of an argument was that I was so connected to the jury and so passionate, and I was overwhelming them with my presentation as opposed to the facts, and I couldn't even believe that this argument was being made, because during oral arguments, it was actually being discussed, and I'm thinking to myself in my head internally, you mean we have to take zip off the fastball? We have to be less effective? We have to be less capable in order for a trial to be fair? It didn't succeed in the end, but I've seen those arguments that your presentation overcomes. It was so powerful. Have you ever seen that in a case that you've handled?
I have, and the argument was exactly what you said. They said to me, listen, this finding was not based on the facts presented. Instead, it was based on the passion and zealous advocacy of that particular prosecutor. And yeah, they had to make the argument. I didn't find it to be true, but you do have to weigh that when you're determining how do you best use your personality to convince a jury of the facts that are in front of them.
Yeah, it reminds me of a case where I also had where one of our police officers was accused of being too kind, and that's how he got the confession. But you can't make it up. I guess you got to sometimes grab for the straws, Judge. All right, we're going to go back to some more of the prosecutor's opening. Let's take a look at his demeanor for those of you who are watching, and we'll talk about it with the judge on the other end. Holy cow. Hey, Judge, I know you're still there. I think I'm going to have to start moving on to your side of this equation about the presentation, and here's why. You are showing a extremely graphic photo of a skull like that, and it seems like it's just being written out, and we're just saying the words to get the speech over with. There's your opportunity to pause. You give your pre-thing about this may be graphic and it may be real. You can build that up, actually. And what I'm about to show you, I'm sorry, I have to do it. It's important to your consideration of the case. You can actually make it look like it's so bad just by your words before you even show it. But, Judge, if it were me, that's how I would have done it. I'd say be prepared. I'm going to show you something that's extremely jarring, something that's going to be emotionally traumatizing, and I would have put that picture on, and I would have just shut up for a pregnant 10 seconds and let them stare at it. Thoughts?
Bob, I'd be the same way, but that's because I was a prosecutor for many, many years in terms of child abuse and neglect cases, and I'm very passionate about it. And so I certainly utilize all those tools to pause, to head note exactly what that evidence is, and to bring the strength of the pictures into it. I will say that he's using very good descriptive words, even though they're all presented in a very calm, kind of flat, monotone approach. For instance, he talked about the nick in the neck, the still smoldering body. These are words that are impactful. Just how are they being heard by the jury given the presentation? I don't know.
Yeah, and you know that you're right. The words are very, very powerful. I've actually seen people do this, Judge. I don't know if you can see me, but they're literally reading word for word, and they get to the point where they say beyond a reasonable, and they got to turn the page over and say doubt. And that's kind of like what I'm seeing here, because that evidence did not pop like it should. Now, it's going to be impactful. It's not going to lose the day. But listen, we're just going to take a short period of time and take a little bit of a break here, and we're going to come back with the judge afterwards. Thank you. All right, listen, we're having some laughs with the judge offline here with our producers. Gotta laugh sometimes when you're dealing with stuff like this guy, Anthony Kirkland. As a prosecutor, it's about as bad as it gets, and it is the kind of case you want, a death penalty case, because this is what you should be living for as a prosecutor. And Judge Ashley Willcott, if this is not the kind of case that you can live for as a prosecutor, you should get a job, no disrespect intended, with an insurance defense firm, because this has got everything you want in order to feel like your life, your career, your passion, you as a person makes a difference in other people's lives.
Absolutely. And I haven't yet heard anything. Granted, we're still hearing the prosecution's case about mitigating factors. And so it's really hard for me, and I'm pro-prosecution, so it's hard for me to think like a defense attorney, but I'm going to try for a minute. I don't know what mitigating factors they can bring up to offset the aggravating circumstances, to say there's some reason that the mitigating is not outweighed by the aggravating.
You know, yeah, I agree with you. And having done homicide work most of my career, I got to be honest with you, even as a prosecutor, I'd say probably 98% of the people that I've convicted for murder, I either understood or I got it. I didn't agree with it. I understood the motives behind it. I wouldn't say they're bad people. I never like to do that. I think that's judgment for other people, a higher entity than myself to make. But they did very bad things, and they need to be punished for it. But there is a 2% or maybe even less of some that I've prosecuted where you're like, wow, this is just an innately, I hate to say it, evil person. And this is what this guy reminds me of. There's nothing redeeming. There's nothing mitigating. And I think that that's the point that you're trying to make here with this guy.
Yeah, and you have to protect society. It's not only the punishing, but protecting society. Someone told me once that if you look in the eyes, you can sense or see that small 2% that you've just mentioned, Bob. I'm not saying that's a scientific method by any stretch of the imagination, but I will tell you, in all my years, there was only one, and I looked in his eyes, and it did hold true that he was one of those people that commits these heinous, awful crimes, and would continue to do so if he were, and he proved that when he was released, that's his nature.
Yeah, he proved it in a very dramatic way by killing a 13 and 14-year-old girl in horrific circumstances. Judge, I had one time where I was crossing a defendant on a murder case. It's funny you should bring this up about the eyes. And I would tell my wife every time I got home, it was a very extensive cross-examination, many days, that I felt like I had to take a shower because I was unnerved by the cold darkness of the individual, even though I was doing my job. That was what was going on in the back of my head.
Exactly. And the opposite is true too, right? There are most defendants you look at and you know it's bad behaviors, bad life circumstances, bad choices, all of those things. So there's a distinction.
Yeah, Judge, listen, we made a distinction before about the difference between the Colley case and this, and the Colley's deliberating right now, that jury. There are mitigating circumstances that could be argued. It'd be very interesting to see how these two juries evaluate these cases. I say Kirkland's going down in a hot flash. I won't try to spell it again, but I'll trip over my tongue. But we'll see how the other cases turn out. The Colley case turns out. You've been great. You're always a great guest. You always bring it home with regard to your answers and your experience. I know you got to go, but I look forward to seeing you the next time when you can be on, hopefully when I'm hosting.
Thank you, Bob. Love being on. You guys have a great afternoon.
Okay, great. And guys at the Law&Crime Network, we're going to go back to the courtroom and listen to some of that previous testimony, and I'll come back and discuss it on the other end.